Hello, everyone. We're just going to give a couple more minutes for people to join before we get going. While we wait for more people to hop on, I was going to ask if you could put in the chat sort of what city and state. I know we have people from all over. What city and state you're joining us from, just to get an idea of where everyone is right now.
Good morning.
Oh, Silver Springs, Maryland. Thank you for joining. And I'll tell you a bit more once we start, but I am also in Los Angeles County in California. So I see we have a handful of Los Angeles folks. And we will get started in about 2-3 minutes, okay? Just want to make sure that we give some time to those folks that are going to hop on. But this will be recorded, so those that hop on a little late will get this, so I don't want to keep anybody here longer than you need to. I know we're all very busy, so I will be starting soon. Okay, well, let's get started. Like I said, this is going to be recorded. So if anybody misses the beginning, they can go ahead and watch it on the replay that'll be sent. So my name is Genoveva Meza Talbott. I'm an attorney in California. I'm only licensed in California. I've been an attorney for about 22, almost 23 years. My firm is a boutique firm that specializes in helping women and their families protect themselves, their loved ones, and their legacy with things like estate planning, prenups, and friendly divorces, because that is possible. So my background, I went to UCLA for undergrad, and then I went to USC for law school, and I've practiced in Southern California for these last 22, 23 years. And like I mentioned earlier, my law firm is in Los Angeles County in Claremont, California. So just a bit of housekeeping. There will be a Q&A time at the end, so feel free to save your questions as you think of them throughout the presentation, and you can, at the end, bring those up, or you can throw them in the chat, and at the end during the Q&A, we're going to go ahead and go through that chat to be able to answer as much as we can. And then the final housekeeping, the legal disclaimer, of course, like I said, I'm licensed only in California, so the information that I give is only applicable to California, but it is not legal advice because I am an attorney, but I'm not your attorney. So this is all for information and educational purposes only. Okay, so today it is about learning about estate planning. And to give me a better idea, I really would like to know who has an estate plan here. And one second here, I just realized what I did. Technical. I'm a lawyer, not a technician. So here we go. All right, so I was going to say, put it in the chat. Type 1 if you have an estate plan, and 2 if you do not have an estate plan. That'll give me an idea of sort of where everybody is on this estate planning journey. So let's see. So we have, all right, I see some people have an estate plan. Good. Okay. But most people don't, which is really good that you're here. I congratulate you on that, because I know sometimes this is the first step. The first step is people thinking about it and trying to get informed on their own. But then this is the first actual step they take, is signing up for an educational webinar or workshop like this. So, okay, great. Great. Okay. All right. So today we're going to talk about a lot of things generally about estate planning. I think, especially since so many of you do not have an estate plan, I'm going to take the opportunity to sort of give you the 101, right, on estate planning. And then, of course, because most, if not all of you, but many of you are practitioners and are therapists, I'm going to, get into that a little bit so that you have some additional things to consider because of your license and your practice. Okay. So why is estate planning important? Why does it matter? Well, I mean, estate planning, I like to say, is an act of love. It really is. People that create estate plans are thinking of their loved ones. Yes, it is about you, but it is really about leaving things in order for those people that will come in and take care of things on your behalf, handle things for you, and will receive things from you when you pass away. So it is an act of love that you take care of. But one of the things that I also like to tell people is that it's not just about death, right? People think, I think, estate planning, death, if they even think about estate planning. I know this is not a topic that a lot of people want to think about or talk about, but it's not about death. It's about you, right? How do we protect you during your lifetime and sort of your wishes, but your family, your loved ones, and how do we protect them and leave things in order for them, a smooth transitions, smooth passing of generational wealth, right? Things like that. But if you own a business, it's also about your business, right? Because you and the business many times are one, right? If anything, sometimes you are the business. But even if your business is set up a different way, it is still going to be affected by your estate planning or lack thereof. And, kind of to tie into all that, it isn't just about death, it is also about incapacity, right? And so, why estate planning matters? Because you're protecting all of this. You're protecting your loved ones, your business. You're ensuring that your wishes in incapacity are honored, right? If you don't have anything in writing, if you have a designated, trusted people to make those decisions, during incapacity, medical or otherwise, there's a good chance that it might not go as you wish or as you would have intended. And of course, the clarity, talking about business owners, the clarity that it gives your clients and staff if you have a business on what happens during incapacity and at death is hugely valuable. And in fact, we'll talk about it, but there's some legal requirements that you have by holding these licenses about this sort of transition and providing this protocol and plan. But ultimately, why is estate planning so important? Because without it, so without an estate plan, you are opening up your family, your business, everything to legal issues, financial expenses, and just a lot of emotional stress, um, especially for businesses. There is a little example that it's something recent that I handled. I'm still handling because it takes a while. Is there was a spouse that was a licensed tattoo artist and piercing. They had a business. The wife, the husband passed away unexpectedly, right? And the wife thought, well, it's my spouse, it's their business. I should be able to do things, handle it, wind it down. Not so much, right? There are so many technicalities. They say the devil's in the details, and certainly during death or incapacity, there are lots of details. And unfortunately, this spouse, this wife, saw so many roadblocks to being able to do certain things. And, it's been over a year, and we are still in probate court handling the transition and her receipt of the money that was in the business and all the things that he had. Never mind what happened to the employees. It's just a lot, right? And it seems very easy that a spouse or somebody else can just take things and handle it, but without authority, legal authority that you can either get by a judge in court or a document that you prepare, it's just not that easy. So that is why it is so important for you to plan and not leave it open-ended, okay? So now, because many of you don't have an estate plan, I'm going to talk about the very basic and no question. I always say no judgment zone, and also no question is a bad question when it comes to this, right? And one thing I realized as a practitioner, which you might do as a practitioner, that we take for granted certain knowledge that we have. And whenever I talk about estate plannings, I assume sometimes people realize know what that is, and then they ask certain questions, and I realize, wait a minute, let me break it down some more. So these are key documents that every therapist needs, that everybody needs when they're creating an estate plan. But let me just break this down. So these are documents that are part of a plan. So think of your estate plan as an umbrella. The plan may include various things. These documents here are the most common and sort of the minimum documents that we use in California, at least, to create a plan. So, and I say this because I've talked to people and we're having a conversation about their estate plan, and then they say, well, what about a trust? Is that the same as my estate plan? And I said, oh my goodness, clearly I need to make sure to clarify that your estate plan may contain things like a trust, a will, and all these other things. Okay. So if you ever have questions about that in the chat, and I need to get into that a little more, but that's the one thing I've learned to explain. Think of it as an umbrella is your plan, and there's the various tools and documents that we utilize to plan for these incapacity and for death. Okay, so the key documents are, there's going to be two sets. It's the death documents and the incapacity documents, because we're trying to plan for both of those scenarios, right? That's a comprehensive plan, not just death, not just incapacity, it's both. The incapacity plans are, the HIPAA, which you all are very familiar if you're therapists, right? That is an access document. So when I create it for my clients, I am giving them a separate document where they list people that they would like to be able to have access to their medical information. Many people have doctors that require them to fill this out. But sometimes when people are thinking so if they're going to a specialist, they think very specific to that situation and that doctor, and they fill it out and they put their spouse. Maybe that's it. But they're not thinking, like when we start planning, of a situation where they're in this long-term incapacity. And gosh, I would have wanted my sister to also be able to talk to my nurse, right? So it's a little broader look, whereas it's not this specific to this doctor, but it's kind of a broader look that can be utilized with all your providers. So we create that. The other incapacity is the Advanced Healthcare Directive. So unlike the HIPAA that just provides access, the healthcare directive is like a power of attorney. So that gives decision-making power. Very important for medical, to have it during the pandemic. This was a big problem. Not many people had this. Sometimes it's an easy decision when it's like a spouse, right? Doctors, nurses, staff, they realize the spouse is sort of the priority person. But it wasn't always that clear. And it is really terrible because the providers are in this difficult, space to make these decisions. Who do they talk to? Different people. But it also is difficult because sometimes there's different opinions on what to do about your medical care. So again, what do? We create this document where you list the people in the priority that you want to be the decision makers for you. And we get into some detail, end of life decisions and things like that. Hard decisions, right? This is the people that you chose for that. It is definitely tough, but it is important for you to choose and not leave it up to whatever the law says. The third incapacity document that has to be part of this for incapacity is the durable power of attorney for finance. So much like the Advanced Healthcare Directive, this one is decision-making and power. Very powerful document. Has to be also very trusted people, because these are the people that would, when you are deemed incapacitated, they would come with this document and be able to, once they prove, you get doctor's notes, etc. They have the power to do a lot of different things. So it's a very thorough document because we do want those people that you trust to be able to do things for you. Another thing during the pandemic is the most recent example. People didn't have these documents. They didn't have people ready to go to deal with finances, paying bills, right? Calling the mortgage. So their estate was also being affected, right? So when you think about estate planning, people think, oh, my estate correlates to death, but your estate could be at risk if you don't have incapacity planning as well, right? Houses were going in foreclosure. A lot of things were happening because why? None of this, the people weren't in place and the documents weren't in place to avoid and have a ready plan ready to go. So that's the incapacity documents that we use. Can there be others? Yes. If there's children, I include some other documents sometimes to allow parents to have sort of these temporary guardianship documents for their kids. Every family is different, every situation, but that's something that sometimes we include. The other two documents are the will, the pour over will, and the trust. The pour over will is a special will that we use when there is a trust. But it's still a will. It is just a different type, a little shorter. But every adult needs a will. And so that'll be part of a plan that includes a trust or doesn't include a trust. If your plan includes a trust, it'll also include a will, right? It's not one or the other in that case. But the trust is really what's going to do all of the work or most of the work. That's going to deal with death. It's going to deal with incapacity. It's going to talk about who those people are that are going to step in and manage your estate or trust assets. They're going to have a lot of power to do a lot of things. And if you're ever incapacitated, they will manage things for your behalf while you're alive, right? And then, of course, when you pass away, they handle following your wishes in the trust and distributing. If you have kids, they create their trust, right, for the kids and they fund them. So it's a big responsibility, successor trustees. It's a lot of work. They don't really have a lot of discretion. They can't change your plan or your trust. I get that question a lot. No, they're here to come in. They take on this responsibility to follow your instructions, right? Whether you're alive or it's at the time of death, they have instructions to follow. It's a lot of requirements in the law. And yeah, it's important to really think about who those people are going to be. Okay, so let's see. So those are the 5 minimal, most common documents we use. Every therapist, every adult with a child, every adult with real estate. Let me back up there on the probate. I don't think I've talked enough about why probate is something that we avoid, especially in California. Every state is different. Some states have a very simple, efficient, inexpensive probate process. Not so much in California, okay? And so why do people say in California all the time, oh, we put our house in the trust. Why are people doing this? Because when you pass away, there always will be an administration of your estate when you pass away. Either it's going to be done by a judge in a court if your estate is of a certain size, or it's going to be done privately with your estate planning, right? Those are the 2 paths. You create your plan, it's done privately with a lawyer. You don't create a plan, a judge supervises your distribution of your estate. Those are the 2. California, this probate process is lengthy. I think on average it's 18 months or so to get it, which during that time, nobody gets their inheritance. Things are kind of frozen, right? So you can see how that would not be good. It's stressful. Court is always stressful and it's expensive. So in California, the way the fees are calculated for an estate is based on the gross value. People know probate is expensive, but I don't think they know, again, the details. So just as an example, in a state worth $1 million, which I know sounds like a lot, it isn't, because real estate is so valuable here that most people hit that 1 million mark in California. The minimum fees in probate are $46,000, right? So imagine going up. Now you own one house, a rental, a business, some accounts. You're at 1, 2, 3 million easily. You could see where those fees start getting into the 70, 80, 100,000 that comes out of the inheritance that would have otherwise gone to your heirs and beneficiaries. So the expense is a big motivator for people because an estate plan, what on average is $5,000, right? So anyway, I did want to bring that up because I think sometimes I take for granted people don't know. Part of what I do when I meet with people is look at their estate and give them these numbers. We talk more specific. Today, general, in a consultation, specific, right? So that you can really start assessing and making those decisions for yourself of what's best for you and your family. So If you have a practice, which I think many of you do, there's some extra layers. So we talked about the basic that anybody needs, and you certainly need that. But how does this apply to your practice? Well, I'll tell you, it's very similar to attorneys, right? When we're licensed, especially in a very confidential license. I wouldn't say a license for nail technicians is the same as ours, right? There's a lot of confidentiality, a lot of regulation, and really it's all for the protection of our clients, consumers, patients, et cetera. And so think about all of those things. And unfortunately, I don't think our licensing boards are very helpful in telling us all this, right? They certainly, I think, tell us what bad things happen to us if we don't do this, this, or this, but they don't really give us this guidance. But hopefully today will enlighten you a little bit more to continue researching and taking steps. But to protect your practice, just like your family, your personal things, you're going to need to name a successor trustee or a business representative. That is what we do in the trust. In the trust, when we create it, we'll create the successor trustee, those people you trust to step in and manage. And then leave instructions for client care and record handling. This right here, 2 and 3, and ensuring business continuity for income and client transitions is something that me as the attorney can't really do for you because I don't know the ins and outs, but it is done as part of your business where my clients that have businesses, especially licensed businesses, I task them with creating sort of internal documents that are going to provide these instructions for the client care, for record handling. So there's continuity. Even the tattoo and piercing business I was talking about, the wife did not have access to payroll. She knew payroll happened on a certain date. She couldn't access. It was just a mess. How do we pay these employees? How do we do all these different things, right? So as part of a estate plan creation, when you own a business and a practice, that part 2 and 3 is something that is going to be your homework. And it probably should have been done anyway already. Maybe some of you already have that. Great if you do. Then it'll just be incorporated into your estate plan. But in my experience, most business owners and practice owners are so busy, they don't have these things set up yet. And so this is the opportunity to kind of get in that mindset. And then number 4 here, including your business in your estate plan. That's where I come in, right? As I'm creating the estate plan, I put special language in your trust to notify your successors and legal that there is a business, and empowering the people that you've chosen. And then we will technically connect that business to your trust. Just like we put houses in trust, there's a way to connect a business to the trust. Because again, what we want is we want smooth transition. We want, as a lawyer, I always think of, I'd rather put more language in than not. We don't want vague, open-ended things. So that's why our trust can be so long because I'd rather put it in there. And if we use it, great. If we don't, so what? It's just in there. But with these businesses, I throw in a bunch of language to empower these people that you've chosen to be able to do what they need to do. And if they can't do it, to empower them to hire and bring people in. So for example, if you don't have a person chosen, if you don't have some of this, that they can then go out and hire people that have the license to be able to do it. That's what happens with lawyers. If lawyers die without this, the State Bar of California will assign in another attorney to come in and handle and open business files and start doing all the things. Why? Because confidentiality, right? So that's what I do in the language, the extra language that I put into the trust when I have practitioners that own a business. Okay, so common mistakes. And these are not just mistakes that people that are therapists or business owners, this is across the board, but common mistakes is just having a will, first of all, and then neglecting incapacity. So that's kind of a loaded one. So let me talk about that. So having a will is great. If you don't have anything and you have a will, I commend you for at least having a will. Every adult should have a will, right? I tell college students, at least get a will, right? Because you own something, even though you think you don't. You have a car, you have a bank account, so your will is necessary. But one thing a lot of people don't know is that a will still needs probate, okay? So again, a will gets you in probate still. People don't know that. They think when they're will, they can avoid probate. No, it's, if you don't have an estate plan or a will, you end up in probate. If you have just a will, you end up in probate. The only way that you're out of that probate process if you have a proper living trust. The trust is what makes it a private estate and death administration. Okay, so again, if you have a business, real estate, children, you don't want to just have a will, right? Because you're going to end up in that same public forum, expensive forum in probate. And of course, we've talked about it a little bit, just having death planning and not incapacity, huge risk, right? Huge risk for your business and your estate to not have the proper in place, the proper documents and people in the event you're ever incapacitated. It may not happen, right? But you want to have that just in case. The second thing I see here, forgetting to update your beneficiary. So this is something that has to happen regardless, and you'd be surprised how many people don't check this regularly, is your beneficiary designations on all these various accounts, 401ks, banking accounts. So part of what I do in estate planning is this. So why, I think you all know because you're here, but estate planning is not just forms, it's not just documents. There's this very bigger, higher level view of your estate and your family to do an assessment, an audit of sorts to look at all these things. And one of the things I look at and I help my clients is, besides creating all these documents we've talked about, is we then have to look at their assets and how are we going to handle them, right? So we go through each of the life insurance. How do we handle that? How do we connect all this together? And part of that is those beneficiary designations. And it's key because what you have as a designation on a life insurance, for example, that you created, a lot of people, when they start a job 10, 15 years ago, they set that person, they forget, they pass away. Guess what? It's a boyfriend, girlfriend they had from, back then. That's the person getting it. Oh, but I have a will. Everything goes to my kids. Doesn't matter. It's a contract. The life insurance will send the check to the person there. So very important that part of what we do is look at all these different things. The next one is something that is become more and more important and is overlooked. So much so that I recently created a worksheet for my clients that I provide on this digital assets and practice records. We are so cloud heavy now for security reasons. It's not like before where everything, the boomer generation, everything was in papers. There was files and papers. We might have some, but I know my practice is more and more green. And so what does that mean? There's a lot of access issues that encounter for laptops, phones, software, things like that. So that's also a big problem. The last one is the funding of your trust. So this one, again, one of the reasons that people end up in probate is because, and this happens a lot with older plans, like I get a lot of adult children that come to me, their parents pass away. Their parents did a plan like 20 years ago. They created their estate plan, they got their binder, they put it in a closet, and that's it. They didn't do anything. And so then they pass away and their kids find these documents and they realize, oh, they never funded, they never put things in your trust. So your trust, think of it when we create it, it's like this empty treasure chest. It's empty. And so part of the process we do is, okay, now that we create it, you got to put things in it, like formally, legally. There's certain documents, like the business is one type of document. A home is a different type of document. So that's called funding your trust. It happens so often that people do not fund it at all because their lawyers or whoever they did not educate them on this, they didn't understand, or they partially fund it. So then you end up still having to deal with a little bit of the probate court to try to grab those assets because we want them to go into this treasure chest. Because why? Then the treasure chest empties out to your beneficiaries, your kids, etc. So again, working on an estate plan, it has to be thorough. It has to be comprehensive because all these various mistakes that can happen and do happen often ultimately end up with issues, expenses, and a lot of times probate court. Okay. I have a special slide for this because again, like I said, it's become something a lot more important lately. I just did a presentation earlier in the year just on this alone. But when we talk about digital assets, sometimes people think cryptocurrency and things like that. And Yes, those have a value and they're part of your estate, but sometimes there's assets like photos. And in this day and age of us having content and videos and all these other things, that can be part of what you need to worry about and make sure there's a plan. But your email, access to email, so much of our bank statements now are in emails. Who gets paper statements? Right? So if you think about logistically, these people coming in to gather and manage, how are they going to know where your bank account is? There's no statement folder, probably. It's all in your email. How do they access the email? Website. How do they adjust things on the website to show this business is now closed, or instructions? EHR platforms, you use those types of things, right? How are those accessed? So telehealth, so much. We take it for granted. It's a little overwhelming. Again, I created a worksheet for my clients now because I realized this is overwhelming, but we need to start documenting, naming people, giving people access, telling them where to get and how to get access. And of course, on the business, it's even more strict who would do that, right? And then login infos and keep that in a secure place. So again, things that are becoming more and more important as we go green, as we go tech, as we go cloud-based. Okay. And of course, there's ethical and legal, very similar to lawyers here. We have to think about the confidentiality and sort of those rules that we must abide by for handling client files who can. I always recommend my clients that are licensed, different licenses, to contact their licensing board and see if they are helpful. A lot of times they're not, but at least you've asked, right? What tools, resources do you have for these transitions? Because they might have it and they're just not providing it to people. And every license is different. So I definitely recommend that. And, malpractice insurance and all that. A lot of times it also is tied together. So there's all those extra layers for people that have licenses that, other people might not. All right. And of course, if you're a solo, even more. So, a lot of times when we're solos, as in I'm the only attorney, but I have a team and all that. But sometimes there are true solos, as we call them in law, that is literally them handling all things. So again, very important to name in that separate document, the colleague, the person with the same level of access to you to be able to step in, detailed instructions, right? Transition procedures, emergency, very, very more important to set up if you are a true solo practitioner, okay? All right, so to get started, well, I would say the first step is to create two main documents. Start putting together, if you haven't already, maybe some of you do, a list of all your personal assets and a list of your business assets. The personal assets are very important because that's when you start thinking about access issues, what you want to happen. Part of my estate planning discussion and education with my clients is telling them, hey, we always need to think about who would be the next owner, who is the next owner of something. And then we set up to create a way for that person or entity, if it's a charity or things like that, to receive it. But it starts off by listing this. You'd be surprised how my clients, when they come to me, that's the first time they've really sat down. And if they have a spouse, their spouse, to sit down and really put in one place all of their assets and start kind of tracking them, because life evolves and you just start creating and adding new things. Well, creating an estate plan, that's part of what I help them do. It's sort of the first step in the homework is these lists. And then after that, which is the first one is a little more technical, tedious, right? If it's the first time you're doing it, unless you have a financial advisor and if you're that type of person, you might say, here, print, it's ready. Not many people have that. But if you do, great. Number one is done. But the second one that sometimes is a little harder for people is talking about and thinking about those people you would choose, those trusted people for the various positions, right? The people that would be the incapacity for medical, the power of attorney for financial, guardians for your kids, who would handle death things. And these, sometimes some people, it's the same people rotating positions all the time. Sometimes it's not. Some people will have a large group of close-knit friends, family, great. a little easier or not. If anybody's planned a wedding, sometimes having a lot more is actually hard because you have to choose among them. And some people have a very small group of people they would trust for these positions. Again, also difficult. So this second part, again, when you work with me, that's part of what we're doing together as part of the homework, but that's a tough one. It's important to start thinking about it, start discussing it with, maybe if you have a partner, spouse, with them, with the people that you think, because a lot of these are big responsibilities and you need to kind of make sure those people are on board, right? So that's something that you can start now, thinking about it, and talking about it. And then once you have those and you feel ready emotionally and kind of planned, then you talk to an attorney, right? Who understands all of this, because this can be overwhelming. I understand that. But the attorney that works with you should be very education focused. I know I am, to explain why you're doing things, right? How it works. I think that maybe some decades ago, older practitioners were not so much focused on this sort of education aspect. So this is where you get a lot of these boomer clients, and that would create their plans and they were never told how it works. What are these things that we have, these papers, right? They would just, and so it doesn't quite work that way. You need to understand. And from point A to B, when you're working with your lawyer, they need to explain. They need to explain how things work so you understand what each document does. Remember this treasure chest? You have to understand funding, how things are supposed to flow. How do we connect things to your estate plan, right? To avoid court and all the issues. So really vet your attorneys well. There's every type of attorney, right? Every type of practitioner of every type. So I just emphasize that they educate you along the way, constantly explain so that you really get it. Okay. And as part of creating your plan, you need to always fund it. Funding is a process that some lawyers do for you. Some lawyers provide guidance for you to do it. And there's a whole different offerings for that. But make sure that funding and doing that well and properly and timely is a big part of your plan. Okay. And then ultimately, I think you get it, but it is not a set it and forget it type of plan. You don't create an estate plan and then you're done, check it off. That's it. No. Think of, I always say, a living trust lives with you, it grows, right? You create the foundation, and then as life changes, children, relationships, wealth, you should be adjusting that, okay? And that's why we recommend, reviewing it. I know I send my clients sometimes, if they don't reach out to me, I'll reach out to them and say, hey, anything new that's happened that you want to talk about, to see if we need to adjust. Adjustments to estate plans are formal. Okay, so you do need to think about the maintenance is a formal maintenance. It's not scribbling, crossing things out. That's not how it works. So again, your lawyer should educate you so you know this. Okay, and you have to maintain it so you don't run into that situation where I mentioned, these parents passing away and they created their plan in 1997 and never touched it again. It's kind of worthless of a plan, honestly, in 2025. And that happens. And unfortunately, their intent was good, but they didn't have the knowledge or education to really maintain it properly. Okay. But overall, I think one of the things I hear most from my clients, whether they're business owners, practitioners, parents, married, single, that there's this peace of mind to having this, right? It might be overwhelming and stressful to get started. Sometimes in the process at the beginning, these are things that you don't normally talk about, think about, or even sort of divulge, right? It feels invasive a lot of times. I get that. My job and my team, for example, we're very sensitive to that, to make it comfortable, not overwhelming, explain, educate. But the point is that the reason that we are pushing you, gently pushing you to push through and get it done, is because my clients have that peace of mind. And that's what I hear all the time. And my reviews have it too. Peace of mind to create a plan. You will feel so much better when you have this done for your business, for your personal life, right? Because it's really about yourself. That's where it comes for you. But then you'll have that peace of mind that you're leaving things in order as best you can for those people that are your loved ones that will be handling everything for you if you cannot because you're incapacitated or if you pass away. And again, if you have children, I know that's a big motivator for people to leave things for them in order, protected, right? All the things you work for, all that work to gather all this to build generational wealth. It's I say, unfortunately, building is very sexy, right? So people love to think about, talk about, invest in growing a business, creating LLCs and starting businesses, website. I get it. It's exciting. It's sexy. But this part of planning for death and incapacity could just ruin all that growth if you don't have that set up, right? So we need to, it's a mindset thing. We have to remember that these estate planning tools have been used by many communities for many generations to their benefit. But there's a lot of communities that don't have that mindset. And I think it's important that we start looking at it as something that's available to us, right? To also utilize so that all this hard work, this generational wealth that we are bringing and growing can also get passed down and utilize these really great tools that are available to us. So, okay. So we have some time for Q&A, which is great. Hopefully, I don't see many in the chat, but if there are any, this is your chance. Again, I think that I hope this was valuable. I hope that if you haven't created a plan, you're now thinking about all these things I've said. You've thought about all the things you can do to get started, to take that next step, right? You already took a step by being here today. If you didn't have even a basic knowledge of estate planning, maybe you Googled some things, but today, hopefully, clarified some things and it helped you start thinking about what is this going to entail, right? Like I said, the process of every lawyer and firm that does what the process they have for this is different. Every lawyer has their own way. I know for me, it's a very heavy with education, but there is a partnership, right? So you have to be prepared to do some work and work in partnership with my team. So you will, most lawyers will have very thorough questionnaires to learn about your family, right? What your family structure is, to learn about your assets. Yes, we need to know what kind of things you have, because how do I know how to help you protect them and how to connect them to your trust and put it in that treasure chest if I don't know what you have? So yes, you will have to provide me some level of information on all of your assets and the type of assets. Again, that's why the list of the assets and business is so important for you to start doing, because you will have to divulge that. And then again, a questionnaire will likely start asking you about these people, these trusted people that are going to be a part of your plan, right? So I do see here, what do we have? I have, yeah, if you want to raise your hand, Monique, I'll let you handle doing that. Okay, yeah, so somebody asked about the lawyer. Like many practices and different licenses, there's specialties. There's different people that focus on things, and there's so many types of lawyers. The lawyer that you need for this is an estate planning lawyer, not a real estate lawyer, because that's a confusion, but an estate planning lawyer, right? Somebody that handled trusts, wills, probate. So the best bet is to ask for referrals, right, of people you know. If you need to get onto the state bar, and that's helpful, but it's some generic list, right? Word of mouth referrals are always great to ask around, but it's an estate planning lawyer. My information is provided to you in the chat, and I think we're going to send you some information at the end for that. Yeah, I'm looking here to see if there's any more questions. I don't think so. I hope that's because I was thorough and not because you're overwhelmed and don't know what to ask. Please, we have a couple more minutes. I would love to answer your questions. Again, this is a chance. No question is dumb or strange or basic or anything like that. This is a no judgment. So please don't be shy. Okay.
We have a few more questions. We have one
Okay,
from
good.
Bahar about having so she's heard mixed things about parents listing their children on their actual bank accounts through this process. Would this be part of putting things in the trust?
This is such a great question, and I'm so glad because this often, so people adding their children to their bank accounts or to their homes, their title, is very common and very, very problematic. And I'll tell you why. I know it's done with good intention. It's sort of like a DIY just in case. Well, at least, for example, if I'm sick or my kids need to help me, they already are on the account, so I don't need to authorize them. Well, what happens when I die with my house? I might as well add my kid or my children to the home. I see the intention, but it's problematic and in summary, problematic for a couple of reasons. With respect to the bank accounts, right? If you add a child or anybody to a bank account, they own that bank account. So when you pass away, that money becomes theirs automatically. So is that okay if you have one child and you do want them to receive it? That might work, right? However, if you have three children, but you happen to choose one to put in that account because they're the ones that help you, and you think that money will then be divided with your other kids, that's not what the law says. The law says that's their money 100%. Also, in the bank account situation, if you add that person to the account, not only do they own it, but if they own it, that means it's up for grabs if they get sued, if they get divorced, right? So you add an adult child to an account, they're getting a divorce. Guess what? That now that account is part of that divorce. They get sued. Wow, that money in that account is now up for grabs in a lawsuit. So the idea is do not give kids their inheritance before, or anybody before you pass away, because that's kind of what you're doing when you add them to title now. Now, in the adding title to somebody in your home, that's even that's got a whole new set of considerations. So parents do this often, and there are ways to undo it sometimes. But what happens is why you're supposed to give your kids their inheritance when you die and not before that is because there's financial reasons for that, tax reasons. So what you're supposed to do is put your home in a trust. And the trust then is the one that's going to give it to your children because there are legal benefits to that. One of them is if you add a child to your home or somebody else, it doesn't have to be a child, but somebody to your home, it'll be reassessed first and foremost, because that counts as a transaction. Like the county, they'll want to reassess that home. So there's money there, right? And if that house was purchased, 30, 40 years ago, and the property taxes are really low, guess what's going to happen when you add this new person and like, wait a minute, now we're reassessing, right? Because there's been this new transaction. So then the property taxes are going to go to the current rates. That's one. Two, it's what we call a tax basis. So this could be hundreds of thousands of dollars worth of difference. So when you pass away, so say a parent purchases a home and the home was $100,000 when they bought it, right? And then when they pass away, the house in California, very possible, is $1 million, right? So from 100,000 to $1 million, that's capital gains, right? And the government does not let you just keep all that without taxing you on capital gains, right? So when somebody dies and there's capital gains in this example of 900,000, the government will tax the person that dies when it gets passed down, if they sell it. So if the person, doesn't die but sells it, not capital gains. What happens when you put a house in the trust and they receive from the trust, they get what we call a step up in basis, which means that they share in the tax of the person that passed away. So now in this example, the daughter received the house from the trust. The capital gains will be from the moment that she received the 900 or the million to when she sells it. Right? So if she sells it like in a year or two, it's going to go from 1 million to 1.2. She's paying off a 200, not this whole 900. But if you add somebody without, they don't receive it in the trust, they're sharing in that $100,000 value to the 900, to the million. Does that make sense? I know it's a little complicated, but essentially capital gains is huge. And that could be hundreds of thousands of dollars of taxes. That's a huge difference whether if you give it to somebody through a trust when you die, or if you bring them on before you die, and then they're going to share in that capital gains, that huge one. So I hope that answers that question, but this is a very common thing that is done, and people don't understand why it's so problematic, beyond the fact that you add one child and you have 4 kids, and all of a sudden you think that house is going to go to the other kids too. It's not. That child owns it. So there's legal, there's wishes. We talked about it. You know, if it's not in writing and it's not legal, you can't guarantee that it's going to happen. Okay. What else we got here?
I think you touched on this, the next question, which was
Okay.
around the how does it affect property tax?
Yeah.
Then I think we see if we have another one. I have one that I think is what came up for me when I was doing my trust. So I've just kind of transparency. I work with Genoveva on my trust, so she has been very helpful in supporting me in the process. I come from a family that has never had a trust. However, I have witnessed another family experience probate and just was like, I do not want to go through that. It was about a 10-year probate. There was 6 children, 2 different marriages. It was difficult, challenging, very expensive, and a home that probably could have and should have been, you know, like a $1.5 million home. They had to quick sell it at the very end, and everyone got like literally pennies split up between like 8 different people. Not to mention the headaches for years. There's a lot of stuff. So I was just like, how do you avoid that? And I learned from that experience, and it was the estate planning. And then even more so, I was like, oh, as a business owner, right? So there's that extra layer. So anyways, one of the things that came up for me was, and I was like, how does this work? Was my one of my biggest questions initially was like, well, I don't feel like I have enough things, or I don't feel like I can fund it. And what I've also learned in that is that it's the great time when you have less assets. Like we all have assets. It's great when you have less assets because it's less expensive than if you have accumulated all these assets, and then the process is longer, is more expensive versus just funding it over time. It's like a few, thousand here, a few $100s here, just to keep it going. So when people are like, I don't feel like I have enough to get an estate plan, that is actually very false. As mentioned, if you're alive and you have anything at all, like a bank account or even like a necklace that you want to hand over to someone, you should have an estate plan. So I don't think it was a question, it was more of just like a sharing of the importance that I see. But something that I had my own question was like, I'm not ready yet because I don't have enough. I'm not making enough. I don't have enough homes, or whatever the case is.
I thank you, Monique. That is when we poll people, and there's been all these polls, that is one of the #1 things that come up after I don't have time or I don't know how to start. One of them is I don't have enough. And that is a misconception, because if you're an adult and you own assets, you should have an estate plan. What type of estate plan? That's to be determined, right? And I'll tell you, when I evaluate families or people to about estate planning, this is what I look at. So if I have a college student that comes to me, believe it or not, they come to me usually because their parents did it, so they now know. They'll send their kid and they'll say, and I'll evaluate. And usually for them, sometimes at least incapacity planning, right, is important, and a will. Why? Because some of them have assets already, right? They own things, and we want to make sure that at least there's a will to handle that smoothly. But the key thing that I will bring up that I didn't bring up in the presentation is what constitutes having enough for probate. So many people think they have, and sometimes it's cultural, and sometimes there's a lot of different things there about feeling like you have enough or enough for an estate plan. It sounds such a like a big deal, like wealth is necessary, right? But here's the true the determination, at least in California. California thinks you have enough for a judge to oversee your administration if you have more than $184,000, approximately 185,000, right? That is not that hard to reach, because when you're looking at calculated in a state, it's gross. It's not debt. So they don't take away student loans to cancel. No, an estate is calculated like gross. And so I tell people, yes, if you don't own a home, okay, maybe we don't need an estate or trust, but we'll have a will and all those different things. But once you're getting into that category of a collective sort of, you add everything up and you're getting into that 185,000, California thinks you have enough money to make a judge have to do everything. If you have, your estate is very small, there's an expedited process. It's literally called the small estate affidavit that we can do to still grab things that are of less value, $10,000 bank account. You still can't just grab it, people. This is, I think that's the misconception, that things seem logical and easy, and they are not as easy as people think. But to your point, Monique, do I have enough? I don't have enough. Well, if you have something that's getting to the, to that 185,000, you need to do the trust, because you will be pushed into probate court. If you have children, you need a living trust. Why? Because you want to make sure to set up the trust and make, have all that really locked down for them and protect their inheritance. If you have a business, what's the value of your business, right? Again, there's another probate that had to happen because it was a husband and wife. They owned a business. They made cookies, and the business was successful, but they both ran it and all that. But all the paperwork was done by the wife, who was the one that passed away suddenly. So ultimately, it ended up in probate so that he could keep managing it and then sell it or whatever. So again, businesses have their own value, right? And if there isn't a question, so if you don't know the value, so in the one tattoo piercing business I talked about, she didn't think the estate was worth over 200 or 185. She didn't think so. It turned out that there was a lot of money in his business account. She didn't know. So, but regardless, she couldn't just go to the bank and grab the money. That's not how it works. The moment they found out the business owner on the accounts passed away, they froze everything. So probate is the way that she got an actual official letter saying she had the authority to do this, 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 and this. So I think there's a lot of assumptions, misinformation, lack of education, culturally or otherwise, about who needs an estate plan. And the question is not if you need it, but what type. And that's where talking to an attorney, somebody that can do their own, checklist and figure out, can say, oh, this is appropriate for you. I do agree with Monique that creating the plan sooner than later. I get a lot of people say, well, I'll wait till I buy my house. I'll wait till, no, set it up now, and then you just kind of maintain it, right? It'll change and evolve. It's easier to set that foundation when you're growing than to later, remember to do it. It's going to be more expensive and definitely more complex. Thank you for that, Monique.
Yeah.
All right. Okay, so I think we, in the chat, my information was on there. The link to book a consultation is there. I obviously encourage you to take advantage of that if you're in California, so we can talk more specific, right? Today was very general. And we just launched, we haven't officially, but we just launched a new website. So go to the website. There's a lot of information there. And I'm really most active on social media. So I think we've given you that information. But thank you for your time today. Thank you for taking this step, right? It's a mission of mine, a goal to, if I could have a microphone to give this information out to everybody, especially in certain communities. I would love that. And I try to do what I can because I think it's so important that we all realize these tools are there for us. They have been utilized for generations to pass down wealth. And it's time for more people to take advantage of these tools, especially in a climate of instability, volatility, and fear right now. Think of it as one step you can take as well to protect what you have, to ensure that the right people are the ones making decisions for you and your loved ones, and that the right people are the ones that are going to receive those things that you've worked so hard to build. Okay. All right. I think wow, what right on time. Right on time.
Thank you so much. Thank you everyone for joining today, and I hope you take advantage of this free consultation. So have a good rest of your day.
Bye
Bye.
everyone.